Hi, I'm going to go through negligence and I'm going to go through 2 out of the 3 essential ingredients for a negligence claim in this video. So negligence generally is where you fall below an expected standard and then that leads to damage or injury to someone else. In order to bring a claim in negligence, there are 3 essential ingredients. You must owe a duty of care, you must have broken it, and then that causes harm. Causation is a bit trickier, so I'll do that in a separate explainer video. But I want to summarise the first 2 rules here, and hopefully what I've tried to do is help a little bit, especially when it comes to applying in a negligence scenario. Now, if you're applying in a negligence scenario, there's normally quite a lot that you have to do. So let's have a look at what you would have to talk about for your AO1 and apply for an AO2 scenario, and of course evaluate if it's AO3. To start with, the key question for whether you owe a duty of care is now whether there is an already established precedent. Now, this is quite a new addition. This is a very new part of negligence, so don't be surprised if there's no reference to it in some of your older textbooks. If there's already been a well-established precedent, the recent case of Robinson versus the Chief Constable of West Yorkshire Police told us that we no longer have to apply a step-by-step process. We just follow the past ruling. So if you think of really common relationships, such as that between a driver and a pedestrian, or driver and fellow passenger, doctor and patient, employer-employee, those are some examples of really well-established precedent. So I no longer have to go through a lengthy step-by-step process to prove my employer owed me a duty of care. It's assumed because it's a past precedent. So actually the case of Robinson makes things a lot simpler. Now, if there's not been a pre-established precedent, this is a brand new novel situation that the courts have never seen before, then they're going to have to decide and set a template for future precedent of whether a duty of care is owed. If that's the case, we then use the 3-step Caparo test from Caparo versus Dickman. So you only go through Caparo if we have no pre-existing duty of care. Now, in an exam question, that'll normally be fairly clear. It'll be a fairly obvious, well-established relationship, like between doctor and patient, or the exam question will give you a hint. For example, in the past, there was a question about a drone operator. There's no pre-existing precedent for that, and the question actually said this is a new situation that there's never been a precedent on before. So what are the 3 questions that the judges have to look at to decide if a duty of care is owed? Well, the first is whether a duty would be foreseeable. So is it foreseeable that the defendant's actions would affect the claimant? And of course, a key case that we saw in this is Kent versus Griffiths, where of course it was foreseeable that if an ambulance doesn't show up on time, a patient will get worse. Therefore, they owe a duty of care. Next, you've got to decide if there is proximity. In other words, is there a closeness between the defendant and the claimant? Now, proximity can be measured in 2 ways. It can be measured physically. Is there proximity in time and space? Were they in the same place at the same time together? Potentially strangers. And remember, this failed in the case of Balham versus Young because the pregnant lady was far away from the crash when it happened, so she didn't have proximity in time and space. She wasn't the sort of person that the defendant should have been worrying about. We can, however, have proximity through relationship, so you don't have to actually be at the scene of the accident to still be close to the people involved. And we saw that in the case of McLaughlin versus O'Brien. So the mother was nowhere near the crash when it happened, but there was a closeness with the driver who caused the accident through the relationship she had with her children and her husband. So it's quite clear, it's quite foreseeable, that if you do something, it will affect that person and their family. The final question looks at policy reasons for imposing a duty of care. Is it fair? Would it be just? And is it reasonable to ask that that person owed a duty of care to the claimant? I like to think of it in the exam is there any good reason not to? So can you think of reasons around cost, for example? And that's what happens with the police. Remember the case of Hill versus the Chief Constable of West Yorkshire. They said that it would be too much of a burden and it would lead to defensive policing if the police had to owe a duty of care to every individual person. So we use this test only if we don't already have a decision. So for example, if you were to sue the police because you were a victim of crime, there is a fairly clear precedent and the courts will follow the ruling from Hill. I'm afraid you won't be able to win. If there isn't a duty of care, continue if there was. If there had been a duty of care, but often there will be. And then that leads to the next question. You break your duty of care by falling below the expected standard from that duty of care. We measure your behaviour by what we would expect from a normal person. So when it comes to answering this, particularly in a scenario question, the key question that you have to decide here was whether the defendant was a professional. Now, by professional, I would see it as they have to undergo certain specific training to be able to do that job. Doctors are, of course, your key example here. Not just anybody can do the job of a doctor. You have to go through a lot of training and experience to do that job. Similar things with lawyers, of course, you know the training process. Teachers, accountants. If they're a professional, then they have their own test. The Balham test, which of course came from the case of Balham. I think it's easier if you break the Balham question down into two parts and tackle them separately. Did the defendant act like a reasonable, competent body of opinion? First ask, did they act in accordance with a body of opinion that's competent? So in other words, did they do something that other professionals would do as well? But remember, in the case of Balham, that caused difficulty because some doctors would have given the drugs and some wouldn't have. I would then look at whether the action they chose was reasonable. So there was a case called Re Herald of Free Enterprise where they left the back doors open of a ship when leaving port. Unsurprisingly, water got in and the ship sank. It's a very, very famous case. Now, the question was whether they breached their duty of care by leaving the back doors of the ship open, and did they act like a reasonable, competent body of opinion? They argued yes, because other shipping companies regularly left the doors open as well. However, the judges then questioned whether that is also a reasonable thing to do, and they felt that it would be reasonable to shut the doors, thereby almost overriding what the rest of the opinion was. So first off, ask, would other people do it? Would other professionals do it? And then question, yeah, but is that a reasonable thing to do? Okay, it's like my mum says, if other people jumped off a cliff, would you? You could argue others would jump off the cliff, but that doesn't also mean it's a smart thing to do. And of course, your key recent case, hopefully you can see it, is Montgomery versus Lanarkshire Health Board, where they said that the doctor had breached their duty of care by not explaining the risks and the alternative of the caesarean section. If they're not a professional, then we use the reasonable man test. And essentially, this is where we compare them to someone similar. Did they act like a reasonable blank? Did they act like a reasonable employer? Did they act like a reasonable driver? Did they act like a reasonable parent? Yeah, we compare them to what they are. Now, there are a couple of special rules, remember. Most students tend to do okay this with. If they're a learner, they're still expected to be competent. So you're not expected to be perfect because you're a learner, but you cannot use that excuse either. So the key case, of course, is Nettleship versus Weston. We don't compare her to learner drivers, we compare her to a competent driver. That's because the roads have got to be safe for everybody. We can't just let drivers off. There's also the case of Wilshire, which showed the same with junior doctors. It would be the same with trainee barristers. Just because you're a trainee, you've still got to do the job competently for the safety of everyone else. If you're a child, you compare them to someone of the same age. We saw that in Mullins versus Richards, where they were play fighting with rulers. We didn't compare it to a reasonable person. It was, did Dee act like a reasonable 15-year-old girl? And the court thought she had. Now, within that, how do we decide if they've acted like a reasonable driver, a reasonable parent, a reasonable 15-year-old, a reasonable employer? How do we do that? We weigh up the risk factors. And there's 5 key ones to be aware of. Did we have knowledge of the risk? Did you know it was something that could go wrong? And remember, they didn't in Roe versus Minister of Health. What's the size of the risk? So it's common sense that the more likely something is to go wrong, the more a reasonable person will do to avoid it. And remember, in Balham versus Stone, the ball had only left the ground something like 6 times in 30 years. It wasn't very likely. So the fence they had was tall enough. If the ball went out of the grounds more regularly, a reasonable person would go, there's more risk of something going wrong, I'm going to do more about it. You also have to look at the special characteristics of the claimant. Do they have any particular vulnerability? In Paris versus Stepney Borough Council, a reasonable employer at that time wasn't giving out goggles to everybody, but the claimant in question was already blind in one eye. They clearly had a vulnerability, which meant that a reasonable person would think they need extra protection, because if they lose sight in the one eye they have, it's going to be even worse for them. We also have a look at the social benefit. Not all risks are necessarily bad. Some risks have a benefit to society, and we saw that in the case of Watt versus the Hertfordshire Council. In that case, you wouldn't normally use the wrong vehicle to transport the firefighters, but the fact was that the other vehicle was off being used for another job, and there was a woman trapped under the car. The chance of rescuing the woman outweighed the risk of a person maybe getting hurt in the wrong transportation, and a reasonable person would probably choose to try and save the woman as well. We also have a look at the precautions that had been taken in relation to the risk involved. So the more dangerous something is, the more precautions you would take. So of course, if you remember Bolton versus Stone, the fence was high enough in relation to what we were worried about. In Latimer versus AEC, we'd taken enough precautions, putting down sawdust, putting up signs, warning the staff. There was enough precautions in relation to the risk of someone slipping. However, in Haley versus London Electricity Board, the chances of a blind person walking past were high enough that more precautions were required than they already had. So, there needed to be barriers and it needed to be covered rather than just signs. Hopefully that makes it clear. So the Balham test, you simply ask that one question. Did they act like a reasonable, competent body of opinion? Did they do what others would do? And do you feel like that was reasonable? If they're not a trained professional, we just compare them to others like them. Unless, of course, they're a child, and even then you compare them to someone of the same age. But remember, don't give them any slack for being a learner. And then all you do is you think about those 5 things and try and come up to an overall judgment. All things considered, do you think they did what any other person would reasonably do? So taking in mind, were they aware? How dangerous would it be if something goes wrong? How likely would it be something would go wrong? Do people need special protection? Is there actually a reason you're taking a risk? Take all of those things together and come to a judgment. Should they have done more? Have they fallen below the standard that we would normally expect in that position? Or actually, all things considered, have they done what we would have done in the same situation? Even then, that's not enough for a negligence claim. Even if you owe a duty of care, even if that was broken, it still has to actually lead to the claimant's harm or damage. And that's what I'll look at in the next summary.